Distinguished guests, esteemed speakers, and dear colleagues, good afternoon. It's a great pleasure to welcome you all to today's webinar on Reforming International Dispute Settlement, Key Insights on UNCITRAL Working Group III and ICSID Reform. This event is being organized in collaboration between the Istanbul Chamber of Commerce Arbitration and Mediation Center and the Turkish Arbitration Academy, a joint initiative of the Secretariat General of the Presidency of the Republic of Türkiye, İbn Haldun University, and Istanbul Chamber University. I extend my sincere gratitude to all participants joining us from different parts of the world. As we navigate an increasingly complex global economic and legal landscape, the role of investment dispute resolution remains a critical area of discussion. The ongoing reforms within UNCITRAL Working Group III and ICSID represent significant efforts toward enhancing efficiency, transparency, and fairness in investor-state dispute settlement. These discussions shape the future of investment arbitration, ensuring a more balanced and accessible dispute resolution framework for all stakeholders. We are honored today to have with us two distinguished speakers who have been at the forefront of these reforms. Ms. Anna Joubin-Bret, Secretary of UNCITRAL, who will provide invaluable insights into the ongoing investor-state dispute settlement reform in UNCITRAL Working Group III, and Ms. Martina Polasek, Secretary General of ICSID, who will discuss ICSID's contributions to investor-state dispute settlement reform and its impact on global dispute resolution mechanisms. Their expertise and leadership in this field continue to guide us toward a more efficient, effective, and inclusive arbitration system. I would also like to thank Mrs. Senem Vincenzi, Secretary General of ITOTAM, who will deliver an opening speech informing us briefly about ITOTAM. In addition, I would like to thank Associate Professor Dr. Manav Özdemir, Head of International Arbitration and Alternative Solutions Department, General Directorate of Law and Legislation, Secretary General of the Presidency of Republic of Türkiye, who will also deliver an opening speech sharing key perspectives on the development of international dispute resolution mechanisms. Before we proceed, let me briefly share some important details about the structure of today's webinar. The webinar will be conducted in English and will be recorded. We encourage all participants to stay engaged and ask their questions during the Q&A session at the end. You may also type your questions in the chat section and we will address as many as time permits. Once again, I'd like to express my sincere gratitude to all of you for your participation. I hope this event will serve as a valuable platform for exchanging knowledge, fostering dialogue, and deepening our understanding of the critical issues surrounding ISDS reform. Thank you, and I wish you all a productive webinar. As I conclude my remarks, I'd like to hand over the floor to Mrs. Bahçekapılı Vincenzi for her opening speech. Mrs. Vincenzi, the floor is yours.
Thank you, Professor Yeşilırmak. Good morning and good afternoon, distinguished speakers, guests, and dear colleagues. I'm Senem Vincenzi, Secretary General of ITOTAM, Istanbul Chamber of Commerce Arbitration and Mediation Center. It's a great pleasure to welcome you all to today's webinar on Reforming International Dispute Settlement, Key Insights on UNCITRAL Working Group III and ICSID Reform, jointly organized with Turkish Arbitration Academy. Let me briefly introduce you our arbitration center. Istanbul Chamber of Commerce has been providing arbitration service since 1979 and has been a pioneer in the development of institutional arbitration in Türkiye. To this date, numerous national and international disputes have been resolved through Istanbul Chamber of Commerce Arbitration Bureau. The Istanbul Chamber of Commerce has played a key role in promoting, supporting, and further developing arbitration over the years. In order to provide arbitration service parallel to international practice and align with the modern arbitration rules of arbitral institutions, Istanbul Chamber of Commerce completed its work on setting up its autonomous arbitration center and on drafting the new rules in 2014. ITOTAM, founded in 2014 as an attached body to the Istanbul Chamber of Commerce, is an independent, neutral, impartial arbitral institution that provides efficient dispute resolution services for both national and international parties. ITOTAM's dispute resolution services are available to all contracting parties without any membership requirement. ITOTAM services are available for any commercial disputes regardless of the nationality of the parties, the place of arbitration, and the applicable law. Arbitration proceedings are administered by the ITOTAM Arbitration Court, which is composed of experienced arbitration practitioners and ITOTAM Secretariat. ITOTAM arbitration rules entered into force on April 9, 2015. In drafting the rules, the UNCITRAL 2010 arbitration rules, as well as ICC arbitration rules 2012, and other modern institutional arbitration rules have been taken into consideration. Taking into consideration the recent developments in arbitration, ITOTAM has revised its rules in 2012, and current rules are 2021 arbitration rules. In 2016, emergency arbitrator rules and expedited rules are entered into force. As I said, the current rules are the 2021 rules. Although the ITOTAM Arbitration Court has developed practice to address the complex arbitration issues, new provisions are incorporated within the new rules. During the revision of former 2017 rules, mainly the 2021 ICC rules, and current developments in international arbitration practice have been taken into consideration. Within the new rules, new provisions for complex arbitration issues such as joinder of additional parties, consolidation, claims between multiple parties, third-party funding, party representation are incorporated into our rules. Since 2021, there is no official arbitrators list in ITOTAM, but we have an arbitrator pools in order to share with the parties if requested, and for the appointment to be made by the arbitration court. The court makes appointments taking into consideration diversity in arbitrators in order to avoid repeat appointments. Regarding mediation and MEDARB services, in 2017, ITOTAM mediation rules and mediation arbitration MEDARB rules are entered into force. At ITOTAM, the mediation and MEDARB proceedings are conducted under the supervision of the Arbitration Court and the ITOTAM Secretariat. ITOTAM, while providing arbitration services impartially, independently, transparently with international standards, remains to the most cost-effective center in Türkiye with its reasonable arbitrators' fees and administrative expenses, pursuant to its cost tariff updated in 2024. The cost tariff and the calculator are accessible on our website. To talk about statistics, looking at the past 5 years at ITOTAM, the average duration of arbitration proceedings has been approximately 11.5 months. Under the ITOTAM arbitration expedited rules, arbitration proceedings for disputes under the 2 million Turkish liras, approximately $55,000, the average duration is 4.5 months. In addition to commercial arbitration cases, we received our first investor-state arbitration case at ITOTAM in 2023, arising from the bilateral investment treaty between Türkiye and Islamic Republic of Afghanistan. Our efforts continue to expand ITOTAM's inclusion in more BITs in the near future. ITOTAM is also a member of IFCIA, International Federation of Commercial Arbitration Institutions, and has developed cooperation agreements with different arbitration centers from all around the world. ITOTAM has engaged in different national and international activities, projects with different institutions. In order to promote and strengthen the use of ADR methods and raise awareness of these methods, is regularly ITOTAM organizing training programs, webinars, and educational events. ITOTAM has been attending the UNCITRAL Working Group II, working on dispute settlement, and Working Group III on investor-state dispute settlement as a part of Turkish delegation for more than 15 years. From the very beginning of the ISDS reform, ITOTAM attended Working Group III and shared its reports regarding the working group sessions with related authorities. ITOTAM, as a member of Turkish delegation, has been contributing to Türkiye's submissions before UNCITRAL. ITOTAM, as of 2014, is publishing these reports on its website. The ongoing reforms with ICSID Working Group III and ICSID represent significant efforts towards enhancing efficiency, transparency, and fairness in investor-state dispute settlement. These discussions shape the future of investment arbitration, ensuring a more balanced and accessible dispute resolution framework for all stakeholders. Today, once again, I would like to thank our distinguished speakers, Ms. Anna Joubin-Bret and Ms. Martina Polasek, and we are honored to have them today with us. I would like to also thank to all participants for their interest. I see a huge number of participants today are with us today. I would like to also extend my gratitude to Turkish Arbitration Academy, to our moderator, Professor Ali Yeşilırmak, and especially Ms. Manav Özdemir in organizing this important webinar. And I wish you all a very fruitful and productive webinar. Thank you very much.
Now I should pass the floor to Associate Professor Dr. Manav Özdemir. The floor is yours.
Distinguished speakers, guests, and arbitration practitioners around the world, it's a great honor to welcome you all to this significant event jointly organized by Turkish Arbitration Academy and Istanbul Chamber of Commerce Arbitration and Mediation Center, ITOTAM. Secretariat General of the Presidency of the Republic of Türkiye, İbn Haldun University, and Istanbul Commerce University signed a cooperation protocol to train arbitrators and arbitration lawyers in the developing field of national and international arbitration in Türkiye in 2021. And with this protocol, the Turkish Arbitration Academy was established to contribute to the development of the arbitration in our country. We signed cooperation protocols with Turkish Justice Academy, Istanbul Arbitration Center, Union of Chambers and Commodity Exchange of Türkiye, we call it TOP, the Istanbul Chamber of Commerce Arbitration and Mediation Center, ITOTAM, Energy Disputes Arbitration Center, TOBUYUM Mediation and Dispute Resolution Center. Our current priorities are training arbitrators and arbitration lawyers, also practitioners in this area. With this aim, we organize international and national webinars, in-person symposiums about current developments in arbitration. We publish these events as a book. We are here today at a time when international dispute resolution is undergoing substantial transformation. As global economic activity intensifies and cross-border investment expands, the effectiveness, legitimacy, and accessibility of dispute settlement mechanisms remain at the forefront of legal and policy debates. Over the past years, two key institutions, UNCITRAL and ICSID, have been at the center of these reform efforts. The work of UNCITRAL Working Group III has sparked global discussions on the reform of investor-state dispute settlement, ISDS, addressing concerns related to legitimacy, transparency, and the balance between investor protection and state sovereignty. Meanwhile, ICSID's latest rule amendments, which took effect in 2022, represent the most comprehensive reform of its arbitration, conciliation, and newly mediation rules to date, aiming to enhance efficiency, accessibility, and procedural fairness and transparency. Today, we will explore key insights from this reform process, discuss their implications for international arbitration, and assess their impact on states, investors, and arbitration practitioners. As a country with an expanding role in international investment and a dynamic arbitration landscape, Türkiye is closely following these developments, ensuring that its dispute resolution framework aligns with evolving global standards. We, as a Turkish delegation, participate in international meetings and working groups as ICSID and UNCITRAL Working Group II and III. We take an active and proactive role under the coordination of our Directorate General of Law and Legislation of the Presidency. The country contribution was prepared by holding meetings with the Minister of Industry and Technology, Minister of Energy, Minister of Justice, Minister of Trade, Saving Deposit Insurance Fund, ITOTAM, and other related institutions. Also, we attend the UNCITRAL Working Group III meetings with representatives of Ministry of Industry and Technology and ITOTAM. I would like to extend my sincere gratitude to our esteemed speakers, Ms. Joubin-Bret and Ms. Martina Polasek, whose expertise will provide us with valuable perspectives on these reforms. I also thank our distinguished participants for joining us in this important webinar. With that, I wish you all an insightful and productive discussion. Thank you very much.
Thank you, Professor Manav Özdemir. Now let me introduce our first speaker, Anna Joubin-Bret. She is the Secretary General of the United Nations Commission on International Trade Law, UNCITRAL, and the Director of the International Trade Law Division in the Office of Legal Affairs of the United Nations, which functions as the substantive secretariat for UNCITRAL. She is the 9th Secretary of the Commission since it was established by the General Assembly in 1966. Prior to her appointment, in 2017, Ms. Joubin-Bret practiced law in Paris, specializing in international investment law and investment dispute resolution. She focused on serving as counsel, arbitrator, mediator, and conciliator in international investment disputes, served as an arbitrator in several ICSID, UNCITRAL, and ICC disputes. She also published a number of books on various issues, including international investment law. As I understand, she acted as a judge and elected regional councillor sometimes in the past in France. The floor is yours, Ms. Joubin-Bret.
Thank you. Thank you very much. Thank you very much, dear Mr. Moderator, for this kind introduction. And thank you wholeheartedly to the Turkish Arbitration Academy and the Istanbul Chamber of Commerce Arbitration and Mediation Center, ITOTAM. And of course, my special and personal thanks go to Professor Dr. Manav Özdemir for being the instrument behind this webinar and for bringing us all together. And it gives me great pleasure to share this webinar today with my good friend, Martina Polasek, with whom we go back many, many years. So it's a pleasure to be there with you. And I very much regret one thing is not to be there in person, but I think that the next one will be in person in Istanbul. So with these words of introduction and in order to give us enough time to go in depth into the reform of investor-to-state dispute settlement that is still ongoing in UNCITRAL's Working Group III and also in ICSID's rules amendment that took place, that are already finalized and begin to bear fruit, I would like to start immediately by presenting what UNCITRAL has been asked to do, what has been done so far, and what is coming. So let me begin by the mandate. So UNCITRAL is a United Nations commission. It's a commission, one of the two legislative bodies of the United Nations General Assembly. You have the International Law Commission that does public international law codification, and the UNCITRAL Commission, which looks into harmonization, modernization, and unification of international trade law, which is private international law. We have been given a mandate, or the Commission has given a mandate to its Working Group III in 2017 to look into to work on the possible reform of the investor-to-state dispute settlement system. This mandate was a broad mandate in the sense that it is neither finite in terms of duration, but also that it is not limited in terms of scope. And the Commission's established this mandate in 3 stages. The first stage was to take stock and to understand and to map all the problems, the concerns, the difficulties, and the needs for reform of the investor-to-state dispute resolution system. The second was, once established this picture of what the problems and the concerns are and what needs to be reformed, to identify what can be done at UNCITRAL, because not everything needs to be done in UNCITRAL, as we've seen. You know, for example, our friends and colleagues in ICSID had already started in 2016 with the reform, the amendment of their rules. And the third was then the third step of the mandate, in which we are now, is the development of reform elements put together in a framework convention that will allow to deliver on all these reform elements, not only for the future, but also for the 3,000 some existing bilateral investment treaties and regional investment agreements that include investor-to-state dispute resolution. So,
I'm sorry, could you share with us your presentation, if possible?
I can share the presentation if you want, but I was thinking that maybe it would be better if you circulate it after I have finished my presentation, because if I share the slides, you will see the slides, you won't see me. It's not that I'm so interesting to see, but I think it makes it more lively if you hear me talk. And if you can circulate the slides at the end, they're not very many of these slides. What I simply wanted to explain is how UNCITRAL works. And that is the reason why actually this reform of investor-state dispute resolution was brought to UNCITRAL. The reason why, the way UNCITRAL works is that we are an intergovernmental body. So our members are governments, are states, and it's the states and their delegations that sit in UNCITRAL meetings. However, as Dr. Eda explained, the delegations can be constituted of various stakeholders, but also UNCITRAL itself includes in its working groups and in the Commission a number of international intergovernmental organizations and also of non-government organizations. And it is in this context, for example, that ITOTAM is participating in our working group 2, or that the ICSID or ICC are participating in working group 3. They are observers in this working group, and they participate in the same way as the states in making their views and their concerns and their comments known to the working group itself. So UNCITRAL's way of working is that it's intergovernmental, that it includes all stakeholders. So we have representatives from investors, we have representatives from NGOs, NGOs that are more focused on development or sustainable development, for example. We have NGOs that are more specialized in arbitration or more specialized in research. So we have very different stakeholders. And in the case of working groups 4, we have about 400 to 500 people attending the working group at every session. We work also with an expectation, at least in the mandate of working group 3, that the participation is high level. So we need people who can decide. We need people who are able to take decisions at each step of the working group and to also agree on the reports of this working group so that we have a way of moving forward. What I can also add, which makes UNCITRAL an interesting forum, is that we work in a completely transparent manner. Everything that is being discussed, prepared, submitted, and reported in UNCITRAL is available on UNCITRAL's website in 6 languages. So you will find absolutely every input into UNCITRAL's Working Group 3, as well as every output of the working group on our website, including the recording of the proceedings. And last point that I would like to emphasize is that UNCITRAL is working on a consensus basis. So we don't vote in UNCITRAL. It's very seldom. We voted twice in UNCITRAL's history, once for a very procedural matter, and the last time, let me just share that to show you how contentious Working Group 3 was. The second time in UNCITRAL's history, in UNCITRAL's 60 years, we voted on the chairperson for UNCITRAL's Working Group 3. And that was my very first day in office in UNCITRAL, so you can imagine the level of stress that was in the room, competition and stress. So, but other than that, we always work on a consensus basis. We seek not to come to the smallest minimum denominator. However, there is a lot of concessions, there's a lot of compromises that need to be taken by the different delegations to achieve a result that satisfies, or as our chair puts it, as makes everybody equally unhappy. So let me tell you how we began the first 2 phases of UNCITRAL's work. So the first phase, as I said, was really about understanding what the concerns are. We were hearing in many different places from very different voices a lot of criticism about investor-state dispute settlement. There were major demonstrations against ISDS, including, a taxi driver or even my mother in France would know about ISDS and how bad it was for the society. In addition to that, a lot of issues were put on the table about the amount of recovery for the claimants and also for the states that do not always lose these cases. There was a lot of unhappiness about the way the arbitrators were appointed. There were perceptions of conflict of interest that was not properly addressed. So all of this was put on the table. There were concerns that were expressed, for example, by investors, that the whole proceedings were taking way too long and being way too costly. There were statistics coming out, and more information was becoming available as to how much was put on the table by investors to bring a claim and how much the states had to pay to defend these claims. So all in all, we had a number of these concerns put on the table, and we packaged them in order to address them with some methodology and method. We packaged them in 3 broad sets of concerns. A first concern that was shared across the board by the investors and the states was the efficiency of the system, was the concerns about costs and duration. It costs too much and it lasts too long. And of course, the comes in addition to that, the number of recourses brought against arbitral awards, whether for set-aside or annulments, and I'm sure Martina will talk about that later. But the entire proceedings were taking way too long in the view of the end users. We also had, as another bucket, if you want, or group of concerns, the appointment and the overall impartiality and independence of arbitrators. The perception at the outside about these 3 individuals being tasked by treaty to settle the dispute between a sovereign state and a foreign company were really mostly misunderstood, and then, of course, aggravated by the fact that there were cases where you had a person being appointed as arbitrator in one case who was acting as counsel for an investor in another case. You had a perception of it's always the same people. There are multiple appointments for always the same individuals. There's no diversity. There is no regional balance, no regional diversity. It's always the same European and North American 60 plus. I've got nothing against 60 plus persons because I'm myself a 60 plus person. But, you know, the perception was it's always men of above 60 that are partners in big law firms in Europe or in North America, or a few always the same university professors that are being appointed in these cases. So that issue was also very much central to the concerns, which spilled over into a broader concern of legitimacy of the system, which was not perceived as being always correct, which did not have checks and balances, which did not allow, for example, a second view of the case. For example, as we all know it in our domestic systems, there is no appeal in arbitration. Arbitration has this specificity that it's one go at the dispute and it's final and binding. It's the beauty of arbitration, but in the context of investor to state disputes, it was considered as a concern when, for instance, in an annulment case, an annulment panel would say the tribunal gets it all wrong, but we cannot do anything about it because we're not an appellate tribunal. So, I mean, I'm taking a few examples here to show you the breadth, the different types of concerns that were put on the table. And after that stage where we identified really cost and duration, the arbitrators, their ethics, their appointment, their impartiality and independence, and the broader legitimacy and the correctness of the outcome of the system as the main concerns, we went into the second stage. And the second stage was to see what were the possible reforms that could be undertaken in UNCITRAL. And I insist on in UNCITRAL because I would like to really emphasize that a lot of reform were taking place already at that time in different instances. States were revising their treaties. Our colleagues and friends in ICSID were already embarked on the amendment of their rules. Arbitration centers were also revising their rules, and we've heard from ITOTAM that there was also an amendment of the rules at that time. So there were many different efforts taking place at that time. And what was important is to see where can UNCITRAL bring some value? Where is there value added in a multilateral forum such as UNCITRAL, where states sit around the table and negotiate? So we identified at that point a number of reform elements that were submitted by states and by other stakeholders. And we, again, had to organize them in two different sets. One was a set of procedural reforms to look at how the procedure of investor-state dispute resolution could be amended, changed, reformed in order to address the three main concerns I mentioned earlier, and also institutional reforms and structural reforms. And these structural reforms were, and I will talk about it a bit later, the establishment of a first instance court, an international court for investment disputes, which would be like, you know, in many countries we have commercial courts. As our distinguished moderator mentioned, I was a judge in one such court in France, where you hear only commercial disputes brought by claimants that are business people. And there are models out there also of international commercial courts. And so the idea was to establish a first instance court on that model that would hear all investor-state disputes. The second institutional reform proposal was to establish an appellate mechanism, an appellate level above this first instance court that would also serve to as an appellate mechanism for investor-to-state arbitral awards, and a third institution that would be an advisory center for developing countries and least developed countries in investor-state dispute resolution. Because again, one of the perceptions of problem with the investor-state dispute resolution system is the inequality of arms. Not so much in terms of the outcomes, because it's very easy to look at the statistics and you can see that states do not always lose these cases, but it's also very clear that states are not equipped adequately to face these disputes. And most of the time they have no in-house team that will handle it. They will have to go outside to outside counsel. They will have to pay a lot to defend themselves in these disputes. And for some of the least developed countries, for example, that have a case every 10 years, they are totally at a loss when a dispute of that nature appears. And even if they have more of these disputes, they're nevertheless at a loss. So the third structural reform proposal was to establish an advisory center to represent the states in these cases, as we have one that is already working very well in the context of the WTO, the World Trade Organization, in the trade disputes in Geneva. So let me go now into the decision that was taken and into the broad reform elements that were decided by the working group, and on which, you know, year after year, we are developing and finalizing and presenting to the Commission and to the UN General Assembly for adoption. So the first set of reforms was to tackle the issue of the impartiality and independence of arbitrators and the issue of double hatting, multiple appointments, diversity, efficiency that had been identified as one of the concerns. And a proposal that was made very early on was to develop a code of conduct for arbitrators in investor-state dispute resolution. As we were also at that time discussing the establishment of an investment court, it was decided to carry out the development of this code of conduct also for judges that will be called upon to be part of this established investment court. So we developed in parallel two codes of conduct, one for arbitrators and one for judges. We developed this code of conduct jointly with our friends and colleagues from ICSID, and it was a very interesting forehand delivery of the code of conduct, because we worked as the secretariats on different drafts that we presented, that we discussed, that we worked on internally, and then we gave it to the working group, and the working group, of course, you know, ripped everything apart and sent us back to our drafting board. So it was an exercise that took us about 2 years to finalize, and the code of conduct was ultimately adopted in 2022 by the Commission and brought to the General Assembly in the same year. Sorry, 23. Was brought to the General Assembly in the same year. So we presented two codes of conduct, one for arbitrators, one for judges, and they were adopted by the Commission and by the General Assembly in 2023. I'm sure that Martina will tell you a bit more about the content of the Code of Conduct. What I want to say is that when the Code of Conduct was finalized, it was agreed that it would become part of the overall reform framework that UNCITRAL is preparing currently, which is a multilateral convention that states will opt into, and which will allow them to pick and choose from the different reform elements which ones they want to apply to their investment treaties, existing or future. The Code of Conduct, as I said, was adopted in 2023, along with a very detailed commentary that allowed us to give more examples, for example, because the Code of Conduct is fairly detailed in the sense that it gives many, an exhaustive list, for instance, of what needs to be disclosed on the part of an arbitrator in order to be really to provide in-depth guidance to the arbitrators and to make sure that by giving all these detailed prescriptions, we would provide more certainty, both for the arbitrators in what it is that they have to disclose, but also to the parties that when this is disclosed, that's it. You don't need to, bring a challenge on other issues that are not within these prescribed, this prescribed list of elements to be disclosed, of circumstances to be disclosed. Alongside the Code of Conduct, the working group worked also on developing stronger offers for mediation as an alternative, as a credible alternative in investor-to-state dispute resolution. It was decided at that point that there was no reason for UNCITRAL to develop new investor-state mediation rules. Why? Because ICSID was presenting them or preparing them as part of its reform package, and because we had already other of such arbitration investor-state mediation rules out there, but rather to focus on a mechanism to include into existing treaties a stronger offer for mediation. One of the recurrent concerns with mediation, or at least on the part of state officials, is that how can we present mediation as a possible alternative if it's not included in the treaty? How can we persuade our minister or minister of finance or our president to say we are going to mediate this investment dispute if this is not provided for expressly in the treaty, and if the treaty does not provide the how to go about it? And this is what UNCITRAL's Working Group III focused on. We prepared provisions on mediation to be included into treaties and guidelines for parties involved in investor-state mediation. All of this, I would like to say, in perfect coordination with what ICSID was doing, because ICSID was really working at that time on developing investor-state mediation rules. So these investment mediation provisions and guidelines were also adopted in 2023. In 2024, the working group adopted the statute of an advisory center for investor-to-state dispute resolution for least developed and developing countries. As I mentioned earlier, the idea behind this advisory center is to provide the states that are defendants in these cases with the necessary means, support, and legal advice, and even representation for those who need in these disputes. This has, of course, also a beneficial impact for the entire investment promotion landscape, if you want, or ecosystem, because, of course, a state that is well equipped and who knows how to defend itself or has the right support, it will be much easier and much more efficient to conduct the arbitration dispute rather than a state that is not prepared, not appearing reluctant to provide any, a party in an arbitration, as you probably all well know, that is not playing by the rules, it makes the whole procedures much more difficult. So one of the advantages of the center also for the entire investor-state landscape is to make it more efficient when a dispute arises, because there are different areas or places where states can turn to receive the necessary advice and support. This was adopted last year, and we are now in the phase of operationalizing this advisory center. It will have to decide where it's going to be established, because we have currently 9 countries that have offered to host this advisory center. So we have too many candidates for only one place in the world where it has to be established. And also the budget is currently being discussed, and the membership, in order to make sure that we really open it up as much as possible to those that need it. What are we currently doing, and what will be presented this year to the Commission, is a set of, I would call it a toolkit on dispute prevention. Many states, as I mentioned at the outset, reform of investor-to-state dispute resolution did not start with UNCITRAL's Working Group III. It started way back when states realized that they had to be well prepared and be well equipped to manage and sometimes also to prevent these disputes from arising. So there is a lot of good practice, I would not say best practice, but good practice at least out there among the states about how to prevent these disputes from arising. You have countries that have established ombudsman services, for example, in Korea or in Brazil. If you have a dispute as an investor, you go to the ombudsman. You have investment promotion centers that have taken up this role of investment promotion, prevention. You have, of course, an entire range of internal organization in the state teams on how to be efficient to address the dispute when it arises. And you have some states like, for example, Peru, that has a commission, a multi-agency commission that is the first door for investors to go to and try to settle the case before it goes to arbitration. So again, dispute prevention is out there already, but what the working group wanted to do is to have a sort of a manual, a sort of a toolkit for states in cases of dispute prevention, and also tasking the advisory center to be a forum to exchange on these different practices in dispute prevention. So this is on the menu of the Commission this year. And then the 2 big chunks, or the 3 big chunks that are coming, are a set of procedural rules that will reform the procedure itself. And here, I'm sure that when Martina presents the amendments that were brought to the ICSID rules, you will see that there is a lot of commonality with what is being discussed currently in UNCITRAL. The second big chunk of reform is the establishment of a first instance court. And the third one is the establishment of an appellate mechanism. We have advanced quite well on all 3 of these reform elements. We are expecting the rules and the first instance court to be delivered to the Commission in 2026, possibly also already with the appellate mechanism. And we are hoping to then consolidate the entire reform into a framework convention, which will have different protocols attached to it. There will be one protocol on code of conduct, one protocol on dispute prevention, one protocol on advisory center, one protocol on court, one protocol on appellate mechanism, one protocol on procedural rules, and they will then be opted into by the states. They will include a mechanism to apply, I will not say retroactively because it's not retroactive, but to apply also to existing investment treaties. And this is where the UNCITRAL reform is so complicated, because we are not looking only towards the future, but we are actually addressing 3,000 existing bilateral investment treaties, and we are bringing them to a level of, at least in the dispute resolution chapters or provisions of these treaties, we are bringing them to a complete reform. So how are we doing this? We are doing this through a mechanism that is already well known in UNCITRAL when we applied or adopted what we call the Mauritius Convention on Transparency. So in 2013 and 2014, when UNCITRAL embarked on transparency rules and then on the Mauritius Convention, it was decided that these provisions on transparency would apply to existing treaties. How? When a state would adhere to the Mauritius Convention, its treaties would become subjected to the Mauritius Convention transparency provisions if the other state, which is also party to this bilateral investment treaty, also becomes member of this same Mauritius Convention. So if the two states members to the bilateral investment treaty become a member to the Framework Convention on Reform of Investor-State Dispute Resolution, this means that the entire reform package will apply to this particular bilateral investment treaty. As I said, this has already been done in UNCITRAL, but it has also already been done in the OECD in the context of what is called double tax treaties. If you think in terms of facilitation of the investment and trade landscape, bilateral investment treaties and bilateral tax treaties to avoid double taxation often go hand in hand. And double tax treaties are also, you have about 2,500 around the world, and they are also bilateral in nature. So the OECD has developed a convention which has exactly that same function to reform the existing treaties when the two parties to a same treaty have both agreed to the adoption of this convention of the OECD. So to go a little bit now into the details of the procedural rules, because I know that many of you here are arbitration experts, I would just like to flag a few. So many of these procedural rules are the ones that you know already from, for example, the existing reforms that you have undertaken, for example, in expedited arbitration or in bifurcation, in provisional measures. So all of these strictly procedural rules are being revised now in a set of provisions that include provisions on evidence, on bifurcation, on interim and provisional measures, on early dismissal of claims for manifest lack of legal merit, security for costs, suspension of the proceedings, termination of the proceedings, periods of time to make an award, allocation of costs, consolidation and coordination of arbitral proceedings, and third-party funding. So it's pretty much, if you think about it, what our host from ITOTAM has put on the table as the most recent changes to the ITOTAM arbitration rules. But in addition to that, there are several additional provisions to be included into this reform, which relate to the possibility for states to bring counterclaims, to the regulation of third-party funding, to amicable settlement, to the encouragement to exercise or to go to local courts, to local remedies, not an exhaustion of local remedies, but rather an encouragement to use local remedies, waivers of rights to initiate dispute resolution proceedings, limitation periods. For instance, in many treaties, you see that if a claim has not been brought 3 years after the time when the dispute or the facts that gave rise to the dispute have arisen, the claim could not proceed. Shareholders' claims, denials of benefits, and 3 important additional, I would say, almost substantive issues, one being the assessment of damages and compensation and the calculation of damages. Damages in international arbitration and investment arbitration are a big concern, are a big issue. There is no cap. The sky is the limit for an investor to seek compensation. They can ask for $10 billion. At the end, they may be awarded 100 million or 10 million. And the gap between what is being asked and what is being awarded by the tribunal has absolutely no consequences. And when you add to that the fact that third-party funding has an inherent role in increasing the requests for damages, because of course the more damages you get, the more the funders will recuperate on their investment in the case, you will see that this is really an issue that needs to be tackled in the in-depth reform of investor-state dispute resolution. And the second very almost substantive reform element is the issuance of joint interpretations by disputing parties. There is already a mechanism in many treaties to allow non-disputing treaty parties to intervene in the case, not as a amicus, but rather as a non-disputing party. And this is now, we are preparing some provisions to make this possibility for the states more institutionalized in the proceedings. So just to close, to wrap up, what is to be expected now is the statutes of a first instance court, the statutes for an appellate mechanism, the set of procedural rules, and the framework convention, which is going to be the way all these reform elements will be adopted by the states. So if you will, on the one hand, there's still a lot of work on the table, but on the other hand, this work has advanced already a lot. We have already had a first reading of the statutes of the Multilateral Investment Court. We have a very advanced draft on the appellate mechanism and the procedural rules. Everybody thought that they would be so easy to reform. And in fact, when you have a room full of lawyers and you know that the devil is in the details, you know that this is by far not the easiest reform element. So we are still fine-tuning and working on different of these procedural rules. What I can say to end my presentation, and I hope I've been staying well on time, is that please stay tuned. There is still something to come. You will have dispute prevention this year and the big bulk of the institutional reform next year. It's important to continue to be engaged. I would say it's even more important now, even if, and I'm saying that to all the state delegations that are participating in Working Group 3, even if you do not intend at the end of the day to become a party to a first instance court on investment or to an appellate mechanism, you have to be there to negotiate everything just as if you would become a party. Because in 5 or 6 or 10 years down the road, you may decide that you want to join, and then the statutes will conform to what you can live with. If not, it's going to be very costly for you to join an organization that is already established and that does not take into account your main concerns or your, I would say, constitutional bottom lines. So it's really important to be engaged, to remain active, and to negotiate absolutely every comma. No, maybe not every comma, not every word, because we have so many who negotiate every comma already in the working group. But to be really engaged in this reform exercise, which is seeing the end of the tunnel and which we hope will really make a big difference in the investor-state dispute resolution system. I thank you very much.
Thank you, Anna. It's always a pleasure to listen to your speeches. Now, let me introduce you our second speaker, Ms. Martina Polasek. She was appointed as Secretary General of ICSID in 2024. In this role, she leads a diverse team of over 70 legal, finance, and information technology specialists at the world's leading institution for resolving international investment disputes. As a Vice President of the World Bank Group, Ms. Polasek also works with the World Bank Group's senior management team to ensure the 5 institutions of the bank, IBRD, IDA, IFC, MIGA, and ICSID, work in concert to achieve the World Bank Group's vision and mission. With over 25 years of experience in the field of international investment law and dispute settlement, Ms. Polasek frequently speaks and publishes on this exceptionally dynamic area of international and investment law. The floor is yours, Ms. Polasek.
Thank you very much. Thank you. And thank you to the Turkish Arbitration Academy and to ITOTAM, in particular, Professor Dr. Özdemir, for inviting me to be part of this event, this very important topic. And I think it's great that we can do it together with the UNCITRAL to complete the picture of what is going on in ISDS and reform in general. And I think it's very timely because, as some of you may know, ICSID is celebrating its 60th anniversary this week. In fact, it was March 18, the date when the ICSID Convention was adopted and signed by the World Bank president, President Wood at the time, and the forefather of ICSID, Aaron Brockus, who was the general counsel of the World Bank. And later on, about a year and a half later, it entered into force in 1966. And so it's really a good opportunity to take stock of these past 60 years in terms of ICSID's achievement, but also an opportunity to look to the future and see where we're heading and what we can do to improve the system. And so I will try to do that today with a focus on ICSID's past and future contributions to innovations and to reform in ISDS. And I'm proud to say that ICSID has been at the forefront of innovation ever since its inceptions. And we've always seen it as our role to ensure that the procedure is really fit for purpose, that we have good rules, that the system is working as it should, and to identify user needs and adapt to changing demands and circumstances. Because we have to, looking back at the 60 years, we do see a system that keeps evolving, and it is rapidly evolving. In fact, when I started in 2001, we only had about 80 cases at the time and very few awards, and we knew them all. But as we progressed, and that's when these treaties come in, but also the rise in foreign direct investment, we saw many more cases, and ICSID as an institution grew, and we had a larger caseload. And last year, we registered our 1,000th case. But you should know that number 500 was in 2015. So a lot has happened in these last 10 years, in particular, the proliferation of jurisprudence. And we've had now over 350 different treaties involved, both bilateral and multilateral, free trade agreements and others. So you may imagine that there are very many instruments that have played a part in this jurisprudence. And it's perhaps not surprising that at least the perception or that there are differences in the rulings, especially now that more and more is available in public. The awards are often published. That has fueled this conversation about whether a particular case was ruled right or wrong. And it's a good thing. Transparency is a good thing, and we should be looking at it critically. But I want you to know that there is a rapid evolution, and that the system needs to respond to that and adjust on its terms. But it's sometimes a challenge because there are different views on how the system should be changing. And I think that it's important to remind ourselves what the purpose of ISDS and of ICSID is in that context. And I'll start with that because it's meant to promote international investment, and we have to keep that in mind. That was what ICSID was created. It's really, as you know, ICSID is part of the World Bank Group. And the World Bank's mandate is really to foster an investment environment that's conducive to economic growth and job creation. And ICSID is very much part of that mandate. And the underlying premise is that when you do provide dispute resolution services to investors and states at an independent institution within the World Bank Group, that will give confidence to the parties that their disputes will be heard fairly and efficiently, and that will have a positive impact on investment decisions. So basically, inducing investors foreign investors to invest in a foreign state. So that will mobilize capital across borders, create jobs, and have overall a positive impact. And when we're talking about innovation and reform in ISDS, we do need to keep that goal in mind. We need dispute resolution that is suitable for cross-border transactions and in which both investors and states have confidence. Now, what is that? We can have different views on what that should be. Should it be a court? Should it be arbitration tribunals like we have now? But we know that all users want something stable. We want that they want something predictable and neutral and fair. And that is really important, the neutrality of the process. That's why investors hesitated in the past to invest in a particular country because they thought that local courts would be biased. And we should not underestimate the adequate access to adequate dispute resolution for investment decisions. Now, of course, the enforcement of the result is also very important, and especially for the private sector. So there have been very many studies about this, and I can mention one, which is the World Bank Group Global Investment and Competitiveness Report, which surveyed over 2,400 global business executives, who said that a country's legal and regulatory framework, including access to effective dispute resolution mechanisms, is one of the most important factors when deciding to invest. And it also shows that investor confidence and FDI flows increase if there is more regulatory transparency, investment protection, and effective recourse. And states really play an important role in creating this kind of environment that favors business and that promotes FDI. And that is why they established ICSID. You know, states were very much involved in the creation of ICSID. And it was meant to address some of the risks and obstacles that investors face when operating in a state. And in particular, with regard to disputes with that states, it allows investors to bring their dispute before ICSID, before an international organization within the World Bank Group. And that is a neutral forum that both parties have confidence in. So states who sign on to the ICSID Convention, they send a strong signal to the world that they're open to allow access to dispute resolution before ICSID, that they waive their immunity from jurisdiction, and that they commit to comply with and enforce the outcome. But states also provide their own investors with the possibility to use this framework when they ratify the convention. So they allow them to use the benefits of the system, which helps them when they invest abroad. So this is a two-way street, and states are increasingly thinking in those terms. So I would say that the ICSID Convention is itself, and the establishment of ICSID as an institution is worthy the mention as one of the most significant innovations in ISDS. It's really a facility that provides the framework for dispute settlement, but it doesn't impose the use on member states. And it doesn't veer into the substance of international investment law. But it's not about how large a protection you give investors. And I like to quote Professor Andrea Björklund, who said in a lecture, and I quote, "ICSID is like joining a gym. Becoming a member gives you the right to go there, but you never actually have to go." And that's very true. And it's a free membership because states don't pay to join ICSID. They only have to cover the expenses when there is a proceeding against them. So the consent to arbitration and to other dispute resolution methods is separate, and so are the substantive obligations. They are found in investment contracts, in treaties, and investment protection laws. And that is perhaps why it was acceptable to states to waive their right to immunity from jurisdiction. That was a big deal in the 60s, just to do that, and to commit to comply with and enforce awards in a simplified enforcement mechanism under the ICSID Convention. And as I mentioned, it came up into force in 1966. And then 2 years later, it was complemented by the arbitration and conciliation rules. And those rules were based on the ICJ statute and on the ILC model rules on arbitral procedure. So they were not modeled like regular commercial arbitration rules. And that's also what distinguishes ICSID framework from other frameworks. We were specifically designed for disputes between investors and states. And so our rules take into account these special characteristics of these disputes. The fact that you always have or typically as a claimant, an investor, and as a respondent, a state or a state agency. Now, as you know, the ICSID Convention is a treaty and now has 158 states, and it can be used only by member states of the ICSID Convention or investors from member states. in the 70s, there were not that many member states yet. And so ICSID took on an important innovation, the additional facility rules. And so this is a similar set of rules, arbitration and conciliation rules back then, that parties can use even though they are not from ICSID member states. It's not a treaty. These are arbitration rules, but they're very similar to the UNCITRAL arbitration rules in the way they apply. So they're tied to a domestic law, and you have set aside in domestic courts, which you don't have at ICSID. But again, they're formulated for investor-state disputes. So that distinguishes them from the UNCITRAL arbitration rules, which were meant for commercial cases primarily. Now, ICSID has always sought to improve its procedural rules, and it's gone through several amendments starting in 1984. And I can mention one innovative provision back then, which was about transparency. Long before UNCITRAL transparency rules, it adopted a provision allowing ICSID to publish excerpts of awards. So that was already in 1984. And there were further revisions made in 2003 to clarify some provisions, to codify best practices and respond to the growing number of ICSID cases. Now, at that time, the US had begun signing its first free trade agreement, FTA, which, for instance, had provisions on early dismissal of a baseless claim, transparency provisions, and also provisions on amicus curiae submissions, on non-disputing party submissions. And these FTAs also contemplated the possibility of an appellate mechanism. So, for instance, the CAFTA had a commitment to form a negotiating group that was charged with developing an appellate mechanism to review awards. That was in 2003. And in 2004, the ICSID Secretariat issued a discussion paper on the subject, outlining the features of a potential ICSID appeals facility, which would apply to all ISDS awards, so also non-ICSID. But at the time, users considered the establishment of the appellate mechanism premature, in particular in Europe, in fact. And there was no action to pursue that idea. And as Anna mentioned, those efforts have now been picked up again in the context of UNCITRAL. But there were other innovations made in the context of the 2006 amendments. We adopted a provision on early dismissal of claims to eliminate frivolous claims on an expedited basis. That's the one that's called the 41.5 objection that I'm sure many of you have heard about. The possibility for a tribunal to allow non-disputing party submission, so that was adopted as a rule, and the possibility of open hearings. And these rules were later emulated by other arbitration rules, also in the context of commercial arbitrations. And they have been largely viewed as successful innovations. Now, it took about 10 years for the next amendment process, and that's the one that Anna mentioned that started in 2016. We at ICSID had a list of our own ideas for improvement of the process, and we also received many suggestions after consultations with users and the public at large. So it was a very inclusive process. And we did a lot of background work, which were included a review of case law on specific topics, and we basically proposed an overhaul of the rules. In the end, we went through 6 working papers and we had 3 in-person consultations with state delegations over the course of 5, nearly 6 years. So it was a robust and transparent process, and we achieved near consensus on everything, while being mindful of keeping a balanced set of provisions taking into account the interests of both claimants and respondents. And that is very important, to keep that balance to maintain the credibility of the system, because otherwise investors will not use them, and investors are typically the ones initiating the claim under treaties. We've now had over 100 cases under the 2022 ICSID rules, and so far they're working very well. And let me give you a few highlights of some of the innovative provisions. And the first one is what Anna mentioned is a big concern that everyone agrees on: time and cost in arbitration proceedings. It is too lengthy and it is too costly. Everyone recognizes that, but unfortunately, not much has been done about it to address it. And that is something that we're taking on at ICSID. And in our 2022 rules, we have provisions that throughout all of the rules that address this. And it's really a multi-track approach that involves all participants. So for example, there is now a provision that requires all participants to act in good faith and in an expeditious and cost-effective manner. And the tribunal has to consider this at throughout the process, and also when it allocates costs. So it will be required to decide on who should bear the cost of the proceeding at the end of at the latest at the end, and can decide that a party was not, did something that was that lengthened the proceeding or made it more costly, and allocate the costs. And of course, the arbitrators also have a responsibility, and they have to certify that they have sufficient availability to take on the case, and that they will make best efforts to respect certain time limits. And those time limits depend on the type of decision and award. So typically, decisions have to be decided within 30 days, procedural decisions, that is. And an award on the merits has to be rendered at the latest within 240 days after the last submission. So that's roughly 8 months. And we'll be tracking these time limits and publishing the results. Now, we haven't had an award yet under the 2022 rules. It's a bit early for that. But for the procedural decisions, tribunals have been compliant, so that's good news. But I think you will recognize that these time limits are ambitious target. Many current awards have taken longer than that. So everyone will need to make an effort to enable the tribunal to meet those deadlines. And to do that, the rules encourage proactivity by arbitrators to use the tools at their disposal. So, for instance, to propose page limits and hold case management conferences throughout the case. And one other thing that is important to address, time and cost, we adopted this whole chapter on expedited arbitration. And this is not automatic. Parties need to consent to it. But if they do, you can combine it both with the ICSID Convention and the additional facilities, or you could use just specific provisions. So, for instance, how to expedite the tribunal constitution. You could use that method for your regular arbitration proceeding and propose it to the other side. And we've seen actually that being done in requests for arbitration. We haven't seen the use of the consent to expedited arbitration yet, but we're very hopeful that that will be the case, in particular in connection with contract-based ICSID arbitration. That is, you can insert it into your investment contract as the use for arbitration or other proceedings. The next set of changes that were innovative concern the public discussions on reform in ISDS. So third-party funding, security for cost, transparency, and non-disputing treaty party submissions. And most of these are completely new, although many of them reflect existing practice. So, for example, with regard to third-party funding, we approached it to avoid any conflict of interest. The parties must disclose the name and address of the third-party funder immediately upon registration. And if the person is a juridical person, a company, the disclosure must also include the name and address of those who own and control the funder. And we've had a few disclosures. Most of them have actually been made in the request for arbitration, so even before registration. So this rule seems to be working well, and we haven't seen any issues about compliance. Now, the scope of the disclosure is a matter for the tribunal if the parties disagree on it, and we have seen a few decisions about that, but that is also working well. Now, under the new rule on security for cost, and this was very important to state, the tribunal has the power to order security for costs in certain circumstances, considering certain things like a party's ability and willingness to comply with an adverse decision on costs, but also the effect that security for cost may have on that party's ability to pursue its claim and the conduct of the parties. So third-party funding is obviously relevant here, and it can be taken into account. But it's not the sole basis for justifying an order of security for costs. And why is that? Well, if a claimant is a healthy company with assets, then the award can be enforced against it after the event. But third-party funding does play a role, and we've seen that in 3 or 4 decisions on security for costs issued under the new rules. And one of them was, in one case, the case was actually discontinued based on this new rule. The rule enables discontinuance, which was not possible under the old rules. And so we see that the system is now working as it should. Now, there's also a new rule on non-disputing treaty participation, which allows a state to make a submission on the interpretation of a treaty at issue and to which that state is a party. So if you have a bilateral investment treaty, that the home state of the investor can make an interpretation of that treaty by right. But we haven't seen the use of that provision yet. The 2022 rules also provide for greater transparency. So, for instance, there's now a default rule that decisions in the case will be made public unless the parties agree otherwise. And obviously with redactions agreed by the parties. And if the parties don't agree on the redactions, then the tribunal decides. But we see that parties actually often want to customize transparency. So now you typically have a procedural order that deals with that. And at the very beginning of the proceeding, and you have parties designing regimes that fit their dispute and the requirements of the relevant instrument of consent. So also depending on what the treaty or contract involved say. And finally, we sought to broaden the types of ISDS mechanisms available to parties. So for example, under the revised additional facility rules, cases can involve parties that are both from non-ICSID member states and a regional economic integration organization can also be a party. And we actually now do have a case with an REIO as a party. The European Union is party in one case. And finally, and this is very important, we did adopt brand new mediation rules, as Anna mentioned. And what's important to note is that these mediation rules allow a broad access to parties who want to mediate. The ICSID can administer the mediation as long as it involves a state or state entity or REIO and relates to an investment. And it's nice because it's also, we tied it to the Singapore Convention so that the results are capable of being subject to the Singapore Convention and being enforced as a result. Now, we've seen great interest in the mediation rules, and we've received several requests for mediation. In fact, and that's a nice feature in the mediation rules, is that even if there is no prior agreement to mediate, a party can transmit a request to us, and we transmit it to the other party. And although it doesn't lead to a full-fledged mediation under those rules, we have seen that it has started a dialogue between the parties, and which sometimes led to an amicable settlement. And that in itself is good news. So overall, the 2022 ICSID rules are working well, and we'll continue to monitor their implementation to provide you with regular updates. And this is also important for other purposes, as Anna mentioned, UNCITRAL Working Group III is considering to adopt or model the provisions that are being discussed there on the ICSID rules, or have similarly worded provisions for use in ISDS cases under the UNCITRAL arbitration rules or as treaty provisions. And so it's obviously very important that we feed into that conversation to see how the rules are now actually operating in practice. And that leads me to the work that ICSID is doing in other fora. Now, we've been active in ongoing reform discussions at UNCITRAL and elsewhere, especially as far as the procedure reform is concerned, with input about how the ICSID Convention is working, how our rules operate, and our case experience. And as Anna mentioned, we work very closely with UNCITRAL on the Code of Conduct for arbitrators and for adjudicators, and we actively participate in the sessions with comments orally and in writing. And that we see as part of stakeholder engagement, which is really important to address challenges and criticism associated with ISDS. Because after all, this is a system that's created by states for their investment policy goals. And exchanging views on how the system is working from both a substantive and procedural perspective is very important. And it's also important to be as inclusive as possible to ensure we have a system that maintains a balance between the interests of states and investors. And that's the beauty of UNCITRAL Working Group III, that you see not only states participating, but also observers who are very active in providing information and their views on how particular provisions, for instance, would work or would not work. So looking ahead, we'll continue to work with others on reform work, but we'll also work on our own initiatives. And so by way of conclusion, I wanted to mention 3 of these initiatives. The first is obviously to ensure that we're delivering first-class services to our users with an emphasis on time and cost efficiency. We have the tools at our disposal in the 2022 rules, but the rules alone are not enough. If we're serious about reducing time and cost, we really need parties and arbitrators to use the tools at their disposal. We need implementation of best practices, and we also need a change in approach and culture. It's getting out of hand, and we need a reset on it. And we're at ICSID are committed to playing our part in that endeavor, and we'll be rolling out several initiatives. And this will include arbitrator workshops, tracking the time it takes for arbitrator to issue decisions and awards under the 2022 rules, and also investing in advanced technology for case management. Now, the second is to raise more awareness about ICSID's availability for investment contracts. At the time that the convention was drafted, investment contracts dominated the foreign direct investment landscape. The first 18 cases up until SPP versus Egypt were based on contracts. And nowadays, we see a relatively low percentage of contract cases, approximately 15%. So roughly 85% are either based on treaties or investment laws. And you might wonder why. And I think that the answer lies in awareness, because we've become synonymous with treaty arbitration at ICSID, and not many think of us for investment contracts. The transactional lawyers typically consider commercial arbitration rules or the UNCITRAL rules. And this is something that we'll be addressing, including highlighting the benefits of ICSID for contract clauses. Because when investors have the option to choose dispute resolution under treaties, they most often choose ICSID because of the self-contained mechanism, the post-award remedy mechanism, and enforcements. And so these same considerations should be taken into account for investment contracts. Now, you may not see this as ISDS reform work, going back to our origins, but in a way it is, because we need to find an innovative way of how to make ICSID relevant for investment contracts. And so, among other things, we'll be publishing a paper about ICSID's experience with contractual disputes to enhance understanding of these disputes, because I think many people may be afraid of the jurisdictional requirements in the ICSID Convention. And how do I ensure that I can go to ICSID with my contract, not running into a jurisdictional objection? And we'll also issue model clauses and promote our expedited arbitration rules for contract disputes. And finally, the third concerns mediation and early detection of disputes and dispute prevention. ICSID is so much more than just arbitration. We will have met our mandate if we provide the type of services that will help states attract, retain, and expand foreign investment. And we see great potential in this area, as roughly a third of our cases do not go to an award. They are either settled or otherwise discontinued. So where there is scope for settlement, it very much makes sense to avoid the time and cost of arbitrating the case. And we do want to make sure investors and states have the right tools to do so and ensure that they consider mediation even after an arbitration has started. So we'll be offering capacity building in this area and working with our partners in different regions to bring that awareness to everyone. Now, to conclude, I am optimistic about the future of ICSID and ISDS reform, as I've seen how ICSID has found solutions to meet stakeholder needs and demands throughout these past 60 years, and we will continue to do that. Thank you.
Thank you, Martina, for your very extensive and lively presentation. And now we have question and answer time. I think there's a single question coming from ITOTAM. Yes.
Hello. I wanted to ask a question for Ms. Joubin-Bret. First of all, thank you very much for the very informing presentation. I benefited greatly. So I want to ask this question to you, Anna. The proposal for a multilateral investment court is one of the most ambitious reforms discussed within the Working Group III. How do you assess the political and legal feasibility of establishing such a court in the light of diverging state positions, particularly regarding consent, enforcement, and institutional transition? Thank you very much.
Mr. Moderator, I'm in your good hands. Would you like me to answer that?
Oh,
now?
yes, please.
Yes.
Sorry.
Okay.
Yeah.
Okay. So I completely agree with your assessment that there are very different views in the room. When I say the room, I'm talking about our working group room, about the benefits, the downsides and the upsides of having a court system established. For some countries, and particularly for the advocates of this reform element to set up a court, which is the European Union countries, the reform of establishing a court has the advantage of touching upon many of the concerns about the appointment and the behavior of arbitrators, the concerns about cost and duration, the concerns about correctness, the concerns about coherence. So for some of them, there is a clear, it's a sort of a panacea to reform and to take care of all the problems of the system. For others, there is a very strong concern and reluctance about going for a court which, some countries don't have good experiences with international courts and are very wary about the political nature of these appointments that are made by states. So currently, the way that the draft statute of the court is designed, there are many checks and balances to ensure that there is no politicization. There's also the lesson learned from the World Trade Organization that where the appellate body has not been functioning for the last 6 years because one of the countries has blocked its functioning by not appointing one of the appellate judges. So there are many aspects that are being taken into account. Having said that, the entire reform is designed to be optional. So for states to decide which reform element they want to go to. And let me take the example of the advisory center. Not all countries will be joining the advisory center. Some of them have no need. Some of them may think that they prefer to go as they have been going so far with outside counsel. Others think that it's going to be better not to join it unless they have a case that begins at a particular time. So this, I would say, is really where we are currently in terms of who is where. So what we will have is a statute that will be adopted, and to which, in my view, I don't have a crystal ball, but I think that only a limited number of states will become members of this court, at least the first instance court, in the first years. But there are chances that over the years, more and more countries become members of the court, for one good reason, that if they negotiate an investment protection treaty with the European Union or with a European Union member state, they will have to go through the court, because the EU will not negotiate treaties which have other dispute resolution mechanisms. So the population of the court will increase over the years when the number of treaties with the EU increase. I was in Accra yesterday, and in Africa, and there are African countries that are very interested in the investment court, because they feel that for small countries, which don't have a big bargaining power, they will be much more protected in a system of a court with appointed judges than in a system which relies on ad hoc designation of arbitrators to settle the disputes. So I would say that I can see a limited appetite in the room. I defer to Martina, who also sits there, because I'm a bit partial. I'm supposed to be totally impartial, but I'm a bit partial to what I'm hearing, in terms of who is interested in not. I also defer to Ada, who also sits in this working group. There are many countries that are at the border, and who are looking at what is going to happen, and who reserve their position for now. There are some that have already made it clear that they want to become a member. And if you think about it, 27 member states plus those with whom these countries have already signed an agreement, such as Canada, Singapore, Vietnam, Mexico, and a few others, you will have about 30 countries that will become members of this investment court at the outset. At least that's the way I see it. I see that Martina has, because, I sit at the podium in the front and Martina sits in the back of the room. So we have, I would say, almost reflecting views, one from one side and the other from the other.
Yeah, no, I just wanted to come in and, Anna said, that I may have views. In fact, ICSID does not have any view on whether establishing a court is a good thing or bad thing. We do want states to think very hard about what it will mean for investment in general. As I said in the beginning, you have to have that goal in mind, and whether investors are likely to find that it is the neutral and efficient platform for resolving disputes that they want, that they need. That's obviously important. But we are there to assist our member states. If they want a court, then we're there and we'll make it work. Also with the ICSID Convention. What we are afraid of, though, is a system, because UNCITRAL, this working group, is meant to promote unity, meant to have a system that is unified and that applies the same way across the board, so that we do have a stable and predictable legal regime and everyone knows what to expect. That's important, and that's a great goal. But the problem is that in this room, we have heard many different opinions. And what will happen if some do sign on to this system, others think something different, or have some small variations to the system? As Anna mentioned, there will be this treaty with different protocols, and you can sign on and sign off on different things. And the danger is that we will see more fragmentation in the system, because some states will sign on to something and others won't. And so instead of unifying, it might go the opposite way. And that is something that we should all try to prevent from happening, because that would be unfortunate in my view.
Thank you for the question and responses. Anna, you have two further questions. Let me ask them to you, and then you may wish to respond. Does UNCITRAL mention the establishment of local remedy mechanisms, such as an ombudsman, in any of its written recommendations or official documents? This is first question. Second question.
Yes. I can already say yes.
Okay, wonderful. And the second question, you have mentioned mediation as a possible method for resolving investor-state disputes. Could you share any concrete examples where states have actively opted for mediation in this context? Looking ahead, do you foresee an increased reliance on mediation instead of arbitration in ISDS? Furthermore, what are your views on combined mechanisms such as MEDARP and their potential role in enhancing efficiency and consent-based resolution?
Well, I see that it's a question for me, but actually it would be best addressed to Martina, because Martina has the experience of states bringing, or investors bringing cases to ICSID under the mediation rule, and she mentioned that. What I can say is that I've been an active believer and a practitioner of investment mediation for many years. I worked together with colleagues in the context of the IBA very early on in 2012. We issued the first investor-state mediation rules, and at that time we were really not preaching in the desert, but at least we had the impression that we got a lot of eye rolling when we were mentioning mediation. Now nobody rolls their eyes anymore. As a practitioner, when I was in private practice, I advised an investor in a case under a mediation proceeding. I know of many investment disputes that are being settled at an early stage, and I think Martina said that about a third of ICSID cases settle before an award is rendered, and that some of them are going through mediation. But again, I think that the most appropriate person to answer that question of what are the examples is Martina. Can I kick it over to you, Martina?
Happy to take over there. Thank you, Anna. So the beauty about mediation is that it's typically kept confidential. I mean, that's what parties want, to be discussing, negotiating, and reaching an amicable settlement outside of the view of the public. That's really what allows them many times to stay away from pressure, from scrutiny, and so on. So not much information is out in the public. We did do some research, and we understand that or have found that there have been about 40 mediations in investor-state grievances or disputes or whatever you may call them. But we can't really share any concrete examples. And I agree, we need that. We need sort of a best practice example to show that it works, and how these parties reached a settlement, what the process was, what the considerations were, and so on. So we need first parties to be able to willing to share their stories. And we'll be working on that too, because I think that's an important part of educating others about, what can be done. But we do see a great potential in some regions, even more. I was recently in the MENA region in Saudi Arabia and Bahrain, and in fact, in that region, almost half of the cases reach either a settlement or are terminated for other reasons. So depending on the culture and the legal frameworks in place and the ability of government officials to enter into settlements, the rate is higher and there's more potential in that area.
Yes.
Thank you, Martina. Next question would come to you then. After the reform efforts related to the ICSID rules, what kind of feedback have you received? Are there still areas where a reform is being requested?
So we have had only good feedback. If there's any bad feedback, it hasn't been shared with us, except for time and cost. But those are more concerned the older cases. We have had a few awards that are still outstanding for a longer period of time. And we know, and this is a problem also with arbitrator availability. And maybe that's one thing that I would see as a question and a challenge for us, because there's a lot of expectation on us that we will promote diversity, that we will bring in new people as arbitrators. But there's a conflicting expectation that for particular cases, we will appoint the most experienced, the most sought after arbitrators for the particular case. There's a bit of pushback on people who may not have as much experience. And so the result of that is that you do see many of the same names in cases, and these arbitrators are typically very busy. And some of them are good in not accepting too many cases and keeping it to a certain maximum. But it is often hard to predict what will happen during the course of proceedings. And when you think that your schedule looks good, suddenly everything comes together, and you're no longer able to render an award as timely as you would want. And so that is an area that needs to be discussed. And I was just thinking about how this would work with an appeals facility, because lately we've seen so many awards come back on annulment. Almost every other case comes back on annulment. So 50% of our cases are there. And how would this work in a appeals facility, let's say with 15 judges dealing with all of these cases with thousands of documents and with tight time limits? I'm concerned that we haven't really thought through of that operationality of that appeals body.
If I may say.
Okay, thank you for this comment, Anna. If you would like to say anything, of course, please.
No, I just wanted to say that, when you look at the pool of the experienced arbitrators that are being sought, and the number of cases they take, and the fact that they still manage to render awards. I mean, we know of arbitrators that have 50, 70 cases on their dockets that are taking so many cases, and they manage. So I expect that 15 selected judges who will have people to help them to do their work should be able to cope. Where I'm a little bit more concerned, as far as I see it, is at the first level, at the first instance court level, where they will be seeing things very different coming their way, and they will have to build a competence in those subject matters that are very diverse, which, you know, we've seen a pool of existing arbitrators have built over the years. And how are these people from day one going to be competent in these matters? That's something that I'm more concerned about. In terms of the appellate mechanism, it's a little bit different because it's really about the law. So there, we should be able to have people who can get up to speed faster. The first instance, I'm more concerned, especially with the selection mechanism that is currently being contemplated, you know, with these vetting and states submitting and calls for interest, expressions of interest. So, but I think it's our role, Martina, isn't it, to be a bit skeptical and to sort of refrain the enthusiasm of our member states and tell them, be careful.
I have seen annulment committees also struggling with the amount of submissions and so I am concerned about, you know, how to put the case together in a way that will be digestible for the appeals body to meet those deadlines. So I do think, you know, it's a bit of a, I wouldn't even call it skeptical. It's a bit of a reality check on how these cases are run and how they might fold out in appeals mechanisms, and especially if we do add the possibility of appeal on facts, and interim decisions.
Yeah.
Thank you. One last question coming from Atty Filiz.
So I have actually two questions, but they are interrelated. It's about conciliation. So like what I've seen from ICSID and UNCITRAL has different positions on conciliation. While in UNCITRAL system, it was conciliation rules changed to mediation and a similar understanding. In the ICSID, it's two different rules and conciliation being placed between the arbitration and mediation of that hands. In your views, would we see conciliation in its form more or less? Because as we are seeing, there are attempts from the mediation, but also strengthening the arbitration. Do we really need a system which is less interest-based, but less confidential? So it's an interface between them. And in that hands, would like, if it's possible, what are the statistics after, especially the introducing of mediation? What happened to conciliation in ICSID? Thank you very much.
Thank you. So we do. We've always had our conciliation rules, right, since the very beginning in 1966. And so in treaties, you would see the possibility to consenting to arbitration or conciliation. The offer is there, and it can be accepted by investors. And while we haven't seen that many conciliations throughout our history, we do still have some, and some of them are pending. I can't now say how many are pending, but I think there are about 3 or 4 pending conciliations, because you do have that consent to conciliation out there, which you don't have for mediation in the same way yet. And that's what UNCITRAL and ICSID were working on together, on making sure that that states are aware that, you know, there are these mediation rules. There were also other mediation rules available, and you can refer to them in your treaties. And so those model clauses are out there and can be used. So I think in the future, we'll see more use of mediation than conciliation. Conciliation is good, but it doesn't give you the same flexibility. It's not the same model as mediation. Mediation is a facilitated outcome with very flexible boundaries. And then conciliation, you would have jurisdictional requirements, you would have a commission, and certain formal milestones, including at the end a recommendation by the commission. Well, that's not the idea of a mediator, who really is to bring the parties together to find out what their interests are and try to make them reach a settlement. So that's a little bit of a different process. And I think we're putting the emphasis on mediation at this time.
Yeah, and if I may, on the UNCITRAL side, for many years we've been using the term conciliation, and although I'm personally convinced that there are two different roles, the conciliation and the conciliator has a certain role and the mediator has another role. In UNCITRAL, the tradition was that it was interchangeable. So when we issued the UNCITRAL mediation, or the United Nations Convention on Mediation, the Singapore Convention, we decided to call it mediation and to change our model law into a mediation model law, although it was called conciliation before that. But in terms of what we are currently promoting in the investor-state context, it's really mediation, whereas Martina says the role is a role of facilitator, bringing the parties together to work out their own solution, rather than coming up with a solution, putting it in front of the parties and saying, you may wish to adopt this solution, which is typically what a conciliator would do.
Thank you.
Thank you very much.
One last question to Anna. Have you received any feedback on the contribution of UNCITRAL Working Group's drafts to BITs?
Yes, actually. We first of all, we're working very closely with our brothers and sisters in UNCTAD. UNCTAD is another UN organization that works on investment policy, and is has a very comprehensive research and mapping of bilateral investment treaties that we use also a lot for our work. And we see that some of the reform elements that have already been adopted in UNCITRAL are finding their way now into more recent investment treaties. You see much more prominent role for mediation. For example, just to follow up on the last question, you will see in the most recent treaties that there is really a two-tier dispute resolution provision, which says that first the parties seek amicable settlement, and among the amicable settlement possibilities, there is mediation, and then mediation is, if the parties want to go for mediation, these are the rules and these are the provisions, and then you have arbitration. So it's this has really found its way into the bilateral investment treaty, and also the code of conduct very nicely. We're seeing this being taken up by states. My country, France, has recently issued a call for candidates for arbitrators. And among the very clear conditions for these arbitrators is that they will have to abide by the code of conduct recently adopted by the United Nations, and on which, of course, ICSID has greatly contributed. So we see it trickling down. But you always have to remember that we're talking about states, and states are different animals. They do not, they're not as agile and immediate in their reactions as private companies, for example, who will say, you know, okay, tomorrow we change our contract terms, and these from tomorrow on, our contracts will include this, and that. In the case of states and the negotiation of treaties, of course, it takes some time.
Thank you very much to Ms. Anna Joubin-Bret and Ms. Martina Polasek for invaluable insights that they have provided to us for ISDS reform from UNCITRAL's and ICSID's perspectives. We are also grateful to Professor Özdemir for bringing us together, and Mrs. Vincenzi for organizing this wonderful event. Thank you for participation, for listening us. Thank you.
Thank you. Thank you very much. Next time in Istanbul.
Next
Yes.
time.
We are expecting you to Istanbul, hopefully.
Thank you. Thank you so much.